Manever I say ma PENDREAM TV. PENDREAM TV there, osia dem yopo.
Justice Gertrude Eraba Isaba Saki Tokono is no more the Chief Justice of Ghana. Did you have anything to do with this?
You mean me, Beatrice Annan?
As in MDC, as a political party?
Oh, never. I mean never. I think that as lawyers, one of the guiding principles which we regurgitate, whether we understand or not, is that justice must be done, even if the heavens fall. I want to take you on an imagery. If heaven is falling. And there are reasons why, as lawyers, we say certain cases are celebrated. And we say that Marbury and Madsen in the US, we say in Ghana, Tufo an Attorney General, and a number of cases that we call celebrated because it is done in accordance with law and nothing more. And I think that we ought to do away with any narrative that is not what in law we describe as jurisprudential, that will not enrich the jurisprudence in how a Chief Justice ought to be removed, and shun any argument that has to do with emotions. Because even the emotional arguments I've heard being, thrown around, those arguments are very weak. And I say that even President Mahama's greatest critics would agree that on this note, President Mahama did nothing wrong. In fact, in all the arguments, they have not been able to point to us a single breach of either a constitutional provision, a case law, or what we call principles of laws generally, except to say that this was orchestrated. And this morning, I want our viewers to journey with me to demonstrate to the good people of Ghana that this petition and subsequent removal were not orchestrated. What people don't know is that or they should know, because in the presentation by the chairman of the 5-member committee, he did indicate that the petition that succeeds is the petition where the petitioner is Daniel Ofori. And I want viewers and Ghanaians to know that there is a checkered history between the former Chief Justice, Justice Tokono, and Daniel Ofori, which predates even when President Mahama became a flag bearer of the NDC. He was not even the leader of the opposition then. So it cannot be that this was orchestrated. First of all, Mr. Daniel Ofori had appeared before Justice Tokono at the time when she was a Court of Appeal judge, and she had used what Daniel Ofori would describe as unprintable words which are captured on record. Again, I give you 2 decisions of the Supreme Court in suit number J8/114/2020 and suit number J7/13/2020, where Mr. Daniel Ofori had a case against EcoBank and the Chief Justice ruled against Daniel Ofori. In fact, the evidence on record is that Mr. Daniel Ofori had started a case in the High Court himself and had gone through Court of Appeal, Supreme Court, even to the level of review. And he had succeeded. He was in the process of what we call execution, where you recover the monies if you win a case. And then the Chief Justice, at the time she was not the Chief Justice, started doing things that Daniel Ofori considered not in his favor. And you know the trick. Daniel Ofori himself took a motion to the Supreme Court and said that this Chief Justice was so biased against me that I think that the Supreme Court should not allow her to sit in any case concerning me because of her conduct in my previous cases. And you know the irony. The Supreme Court granted that application and said that there was evidence of real likelihood of bias on the part of Justice Tokonu against Daniel Ofori. And so they asked her to recuse herself on all the cases that Daniel Ofori would bring before the court. That is an important background. Where is the NDC in this narrative? Then after the decision for her to recuse herself, she then became a Chief Justice. Because at the time she was just a Supreme Court judge, and then she became a Chief Justice. The same Daniel Ofori that the court had held that on the basis of the evidence presented, there was a real likelihood of bias on your part, so do not preside over it. There were other cases involving Mr. Daniel Ofori in the at the High Court, two different High Courts. The Chief Justice transfers the cases because, of course, it's her administrative duty to transfer the cases. And then Daniel Ofori lost cases she has already won. The checkered history is there. And I'm sure Mr. Daniel Ofori will have the time. So this is a man that already has issues with the Chief Justice. This is a man that feels that the Chief Justice has abused her administrative powers against him as a citizen of Ghana, and then brings a petition to the office of the president. And we are being told that the man that has started a case sometime 2000 and something went on appeal, even review. All of a sudden, this case will have to be political because of who received the petition. I think that it is instructive to note that even the petitions that the Chief Justice herself leaked, these facts were contained in the petition of Mr. Daniel Ofori. So this background shows that the said Daniel Ofori and the NDC have no public or private engagement. In fact, this is not the business of government or the political party to go and be asking for independent and private cases. Now we are being told that, you know what, President Mahama should not have acted and should not have exercised the obligations imposed on him at law. I think that argument is the most legal. I mean, it's not even a legal argument. It's the most absurd argument we can hear. That a president swore to the good people of Ghana that I will uphold the Constitution of Ghana and I will do just by all manner of persons, every citizen. And we need to situate this within the context that President Mahama is the same president who entertained the petition from the NPP to remove his own appointee, Madam Vivian Lamte. So somebody ought to be telling us what has changed. That because the president exercised his constitutional right to do that which the Constitution imposes on him to do, then something is wrong. Remember, even before President Mahama came to power, Nanado also exercised the same rights in respect of this Chief Justice. And so the narrative cannot change because of the person exercising the constitutional right. I am an avid advocate for procedural justice. That A person is entitled to procedural justice as much as the person is entitled to substantive justice. So it matters the processes that you use in arriving at the conclusion. Nobody can tell me, no lawyer in Ghana can tell me that some procedures were breached before arriving at this conclusion, whether expressly stated by law or in tandem with case law. The laws of Ghana were applied to the very end in the most respectful and courteous manner. And then again, the point has to be made that right is not that which you feel, but rights are privileges which are imposed at law. So it doesn't mean that this morning I feel my husband should have been in the studio with me. If your policy says that we expect only the two of you to be in the studio. So the point has been made that rights imposed at law were not breached at any point in the procedure. Now, it is instructive for me to also say that I've seen that you, the media, have a letter which was authored by my boss, Dr. Callistus Mahama. And the letter is to the effect, it's a communication to the Chief Justice. Let the record also reflect that the letter on social media and that which the media has is the Chief Justice's copy. So the leakage would not be from the presidency because we know, and we do not want people to accuse us of leaking any information. And so the letter which she received had a security feature. And it is that which has been leaked. So let the points be made. Now, having leaked the letter, we are now at liberty to discuss at least the findings as they are captured in the letter, which she leaked herself, because the letter was given to her. Now, the point 1.9 of...
So this is what you're referring to.
Yes.
I see restricted,
and the
right?
restricted is the security feature that was put on it.
Does Jubilee have a copy of this?
Jubilee doesn't have a copy of it. It is only the recipient who has it, so that when it is leaked, we know where it's coming from.
Oh.
So this is her copy that the media has. I don't even have Jubilee's copy.
Okay. So the logic here is, so Jubilee did this for Justice Tokonu and her team, right?
Yes.
But Jubilee didn't keep a copy.
No.
So logically speaking, this can only come from her camp.
Yes. That is it.
Okay.
Because we do not want to be accused of anything, especially when the letter will be emanating from the presidency.
But why? You don't speak for Justice Tokonu and her legal team. But why would her people leak this to the media?
I wouldn't know.
You can't hazard a guess?
No, I can't hazard a guess.
Okay. All right. Go ahead.
So I want us to journey with us and talk about the content of the findings. First of all, the committee says that, in the opinion of the committee, the travel expenses of the Chief Justice and the spouse and child amounts to misapplying public funds, and which cannot be explained in law and in policy. And people say that, you know what, it is not so grave a misconduct. And so why would the Chief Justice be removed? It's like people saying that, you know what, yes, stealing is an offense, but because she stole something small, you should not be convicted. That is the logic and the invitation that we are being given. But it is also important to know that the Chief Justice is the head of the judiciary.
Yes.
And has supervisory jurisdiction over the judiciary. And so, do you know that when the Chief Justice delivers a judgment, not even the president can disobey the judgment. Not even parliament can disobey. So her words, even if they contain grammatical errors, were laws and they were binding. And if anybody tried to, disobey it, however absurd you think it is, high crime, the Constitution says, is what you'll be guilty of. And so I want to tell you that this Chief Justice delivered the unanimous decision in the case of Kwame Bafo-Boni, alias Abronye, NPP's Abronye, and the AG. What was the case about? You remember Parliament had determined that spouses of the President and the Vice President could be entitled to the payment of salary.
Yes.
And then Honorable Justice Dafiamikpo went to court. The court said that at the time Mr. Dafiamikpo was coming to court, the matter had not crystallized. So we don't want to go into the merit. Then the NPP savior, Kwame Bafo, alias Abronye versus AG. In that case, the Chief Justice delivered what will be considered a very beautiful decision. And although it is long, I want viewers to, and I crave your indulgence, that she set the standard herself. This was a unanimous decision, and she delivered it. I've read this judgment like, like the back of my palm. This is what the Chief Justice said. On the very face of Article 71, the provision is very clear as to the intention of the framers of the Constitution to place the determination of the emoluments of distinctively identified groups of political officials directly in the hands of the President and Parliament. And then continues to say, within the context, we are satisfied that from both the plain meaning of Article 71 and the purposive deduction from its history, when it comes to Article 71, the framers of the Constitution intended for its scope to be kept narrowly focused on only public office holders identified in this provision. There should be no room for a liberal expansion of the named and designated offices. And the model of certain emoluments within Article 71, because it presents a sui generis and peculiar situation that has been actuated by a peculiar need to protect the tenets of democracy. It gets even sweeter here. Then she says, after she has determined that the ambit of Article 71 should be so narrowed, not to include spouses, she concludes and holds, and this is the judgment. The Act of Parliament approving the recommendation to directly pay the spouses of the President and the Vice President's salary that were benchmarked to the salaries of ministers and members of Parliament as part of the emoluments of the President and Vice President is an act that is violently inconsistent with the clear directions, intentions, and purposes of Article 71. It contravenes the spirit and letter of Article 71. Then she holds that by the very definition of Article 71, spouses of President and Vice President cannot be afforded those courtesies. So how did the Chief Justice then come to the conclusion that her spouse and children could be afforded the courtesy she was enjoying as an Article 71 holder? This is her decision. She sets the standard. I am very clear in my mind that the committee will apply the standard. You know why? Because in our jurisdiction, Supreme Court decisions are binding. And even if the committee held a different opinion, they were bound by her own judgment that they could not, as a committee, expand the scope of receiving per diem. She was receiving $2,000 per diem per day, and the husband was receiving $1,000 per day, and the daughter was also receiving $1,000 per day. If they were there for 20 days, your guess was as good as mine. And so the standard that the committee has applied, it is not a standard as set by Beatrice Ananfio. It's a standard that Justice Tokonu herself set. What has changed in our jurisprudence?
But does this apply to the Judicial Service?
Article 71. In fact, in very clear terms, the Judicial Service, judges of the Superior Court of Judicature, are a clear example of Article 71 holders. In fact, it is the very contemplation of Article 71 is the Judicial Service. So that in their case, in the case of executive and parliament, they change every time. They are constant Article 71 holders. So the point has to be made that this can be political. How is anybody trying to convince me that it's a political decision? Then the committee's second reason is that they found merit in the petition of Daniel Ofori that the Chief Justice by herself could not have written to the President to say that I want these justices as justices of the Supreme Court. And you know what? Here, I'm coming to quote the minutes of the meeting of the Judicial Council, where the Chief Justice herself confessed that she spoke to President Nanado. And don't ask me where I got it, because the principle of law is that it matters not how you get it, even if you stole it. And so don't ask me where I got it. This is quotes as was captured in the minutes of the Judicial Council meeting. She further indicated that she had received a letter from the President requesting for additional judges to the Supreme Court bench. She indicated that she received the letter from the Honorable Attorney General and Minister of Justice, Godfrey Dame, dated 20th June 2024, recommending persons for appointment to the Supreme Court. This is where it gets sweeter. The Honorable Lady Chief Justice informed members that she had convened the meeting because she had received a communication that due to the nature of the political atmosphere, I'm sure they had an instrument for measuring the political atmosphere, His Excellency the President was anxious to send the proposed names as well as the earlier nominations submitted by Council to Parliament. These were the words of the Chief Justice. So how is it that anybody expects the committee to come to a different conclusion?
And these are facts.
And these are facts. I am very clear in my mind, again, that any lawyer who gets this will present it to the Chief Justice, to the committee. So the Chief Justice herself is saying that the President said because of the political nature, the letter must then emanate from me. You see, because the proceedings are in camera and the committee members cannot speak, there are so many things they cannot say. And now I want to be optimistic that now that it's over, maybe they should allow us to apply for the records of proceedings. We are happy to read a 10,000-page document. I mean, that's why we are lawyers. We are happy to read it and look at it. So you cannot tell me that unless somebody has a superior jurisprudential argument, that's what the Constitution has provided. It's so not in tandem with the modern tenets of democracy that certain things were, I mean, there has to be, I can't come, because throughout listening to MPP lawyers, I haven't heard anybody make a superior jurisprudential argument, except to say that this was politically motivated. This, I have told you from the beginning, cannot be politically motivated. Then they say that, you know what, the MDC in the past criticized the removal of Charlotte Osei and said that the President did not do well. And so what has changed? In fact, yesterday, I've seen communicators of the MPP pulling out a Ghana Web report saying that President Mahama said the removal of Charlotte Osei was actually wrongful and politically motivated. It's important for the distinction to have. We have to make that distinction. That as lawyers, and I have told you, I'm just an advocate of procedural justice as substantive justice. So it matters how you come to the conclusion, not necessarily the conclusion. And we've had instances in this country. I remember when we were in law school, the very famous case of Salah versus AG. The Attorney General lost, but he made a certain jurisprudential argument, which we call the Kelsenine theory. And the court concluded that with Kelson gone, Attorney General went with him. Because there are theories of law, principles of law that you have to pull in when you are making legal argument. It's not enough to say that it's not fair. It's not enough to say that it's politically motivated. The reason we criticize Charlotte Osei's own is that we said procedurally, you have not been fair to the person. First of all, the petition were actually by faceless people. But a person has the right to know who their accusers are. And that is a fundamental principle in law. This Chief Justice is very familiar with Daniel Ofori. She cannot say she doesn't know Daniel Ofori. She is, I'm sure, the most familiar judge because Daniel Ofori is an avid litigant. He's always in court. So she's very familiar with Daniel Ofori. The ACP who accused her of practically dehumanizing him in court, she's very familiar. So she cannot say that the petitioners are faceless, unlike the case of Charlotte Osei.
Okay.
The point also has to be made that in the case of Charlotte Osei, she was not given the right to have copies of the petition against her.
Okay.
That cannot be in tandem with natural justice. Okay. And you know what? Even in the face of error, in Charlotte Osei's case, they called the petitioners, come to Jubilee House and come and correct.
Okay.
That cannot be justice. And so let no one deceive the Ghanaian people that this is politically motivated. This is not politically motivated.
All right.
If anybody buried herself, it is the Chief Justice who brought this on herself.
Okay.
And in all these, I want any lawyer to point to me. And I'll be happy to hear Kwesi Kwarteng on this.
Okay.
What specific law did President Mahama breach for which reason this would then be politically motivated or unfair? Until then, I think we have to celebrate our young democracy.
All right.
And Mo, while I conclude, you know why we have to celebrate our young democracy?
Why?
Because gradually, President Mahama is telling us that in our quest to reset this nation, in our quest to build the Ghana we all want, we ought not to countenance certain things. And I'm very optimistic that this will send a signal to every appointee that this is the same president that is able to remove Madame Vivian Lamte. This is the same president that is able to sack its appointee merely because she dreams of having money.
Okay.
This is the same president that is able to convict its own party member.
Okay.
And when your name is even mentioned in Galamsey, you'll be referred to Iwoku. And so something right is being done. Of course, when people are used to the wrong system, they will feel a bit pushy and they will not like it. But I can assure the good people of Ghana that President Mahama is committed to upholding the tenets of democracy.
All right.
PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.